Good afternoon, everybody. Welcome to the WG University Weber Gallagher series of educational programs. This is our Workers' Compensation webinar series, and I'm Jeff Newby. I'm the co-chair of the Workers' Compensation practice, and I'll be presenting today with my partner Joe Barucki from the Mount Laurel, New Jersey office. Each month we'll present a current topic in workers' compensation legal issues. We'll present case updates and ways to manage risk in your business. And if you'd like to view this webinar again and share with others or see it again, go to our WG University program. You can go to our www.wglaw.com website, and you'll find copies of the presentation and others under the WG University page. And also, as you'll see on the prompter today, if you have any questions during the course of the presentation, you can send them to questions@WGLaw. We won't be able to answer them live today, but we will get to all of your questions after today's event. So anyway, the first topic we're talking about are defenses to New Jersey workers' compensation claims. And the reason we're bringing this up is there are some soft spots in New Jersey workers' compensation where you can actually win the claims. They're generally going to involve legal issues as opposed to factual or credibility issues. So the first one we're going to talk about is the statute of limitations defense. Now, ordinarily, you would think that the statute of limitations may not be a great defense because if the claim is otherwise compensable, the judges are very hesitant to dismiss the cases. However, things started to change in about 2010, and we're going to go through some of the case law to give you an idea of how some teeth has been put into the statute of limitations defense, specifically in occupational claims. So what happened in 2010, the first case that was decided that started to become somewhat of a windfall was the Huntoon Case. In the Huntoon Case, the injured worker was told in 1998 that his carpal tunnel syndrome was probably work-related. In 2004, he was told by his hand expert that it was, in fact, work-related. So he filed the claim for carpal tunnel syndrome in April of 2007. And surprise, 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 the court and the appellate division both dismissed the claim for violation of the statute. So why was the claim dismissed? The claim was dismissed because the judge and the appellate division both decided that the petitioner knew all he needed to know no later than 2004 that he had work-related carpal tunnel syndrome, and yet he didn't file the claim until 2007, more than 3 years later. So what about the argument but he continued to work, and every day he continued to work, his hands continued to be exposed to mini trauma, so the carpal tunnel is getting worse and worse and worse. And that may have even been the case that it got worse to the point where he needed further treatment in 2005, 6, or 7. But the court said that is not relevant, and case law says that that is not relevant. The key is, when does he have the knowledge necessary to file a claim? When has he drawn a link between the carpal tunnel and his job duties? And that was no later than 2004. So now that we're on a roll, so we win this case in 2010, was there any momentum from that case? Were there any more cases, or was it an aberration? And Joe's going to take over and give you an example of a few more decisions that came out after 2010 that continue to put some teeth into this statute of limitations defense.
One of the things that's really important when you're defending these cases is to make sure that you're getting the records, because as you're all aware, over the course of time, claimants' attorneys always go to their clients and tell them the first thing is, only tell the truth. So if you don't remember, say you don't remember. A lot of times, so if you get a petitioner on the stand for the first time, they're going to say that. You need the records to be able to substantiate your statute of limitations defense, because that's going to be the notice that's placed in the medical records themselves that's going to bolster your defense. In 2013, there was a bilateral knee claim under the Latos case. That one's important because that's another one where they found out in 2000 he started having knee problems, started to tell his own primary doctor, and told that doctor in 2005, but for some reason he doesn't file until 2008. Statute of limitations is 2 years from the time that you know. So basically he lost because he should have filed it by 2007, and he didn't do it in a timely fashion, and the court kicked the case, which was great for us. There was a second one in regard to a low back claim under the Graff versus Mitchell Park claim. Petitioner was a worker who did flooring. So he works for the insured from 1982 to 2002. And he claims after a while that his back starts hurting him. And he notes it in 1999, and he starts treating with a chiropractor. And they put it all over the records there. And for some reason, he doesn't file until 2004. And the court felt that that was too long, too, because he should have filed it by 2001. So that one was dismissed on behalf of an unpublished opinion. And finally, this is actually a very interesting case. A pulmonary claim under Palejo versus Middlesex County was recently decided by Judge Watenko, who is now the director of the division. That case involved a petitioner who was a non-smoker who lived in a non-smoking house. And the argument was that being in the workplace around smokers caused him to have secondhand smoke that caused him to suffer significant pulmonary injuries. I had the opportunity to speak with the judge on this one, and he actually said he went back and forth in terms of the notice aspect of it versus the causation aspect of it. And he wasn't certain whether or not that there was truly causation based upon secondhand smoke. But he did say that the petitioner started to have pulmonary problems in approximately 1990 until approximately 2001, but waited until 2010 to file his claim. And by the time he did that, the court had jurisdiction and found that there was a decent amount of time for him to be able to have filed his claim, and by failing to do so, they dismissed it.
So these are good wins for the employer, and ones that we normally wouldn't expect. You know, winning on technical defenses is difficult, but as Joe said, you need to do your discovery and get these medical records, because you're going to have to find the smoking gun where the employee connects the dots between their exposure and their job duties. Because until they connect the dots, they don't have that 2 years time limitation to file the claim. Some of these cases were dismissed only because they went to trial, and when the petitioner was testifying, the judge asked the petitioner directly in several of these cases, when did you believe that your knee condition or your hand condition was related to your job? And when the petitioner answered and gave a certain date, and it was more than 2 years from the date of filing, that was the final blow. Because a lot of times the medical records don't discuss causation. They discuss the history and a conclusion, but they don't discuss cause. A lot of the doctors try and avoid that.
That seems to be a much more prevalent thing now that they've been brought up on it. I know some of the older claims that we've had, you'll see more information where he'll discuss smoking history and workplace and things along those lines. But absolutely get the records to be able to flesh out whatever defenses you have.
Okay, the next line of defense we're going to talk about, it isn't so technical, but it's far more common. And these are the off-premises injuries. These are the ones that are so fact-specific that we ask you great detail when you provide us with these questions before they get into litigation. And we need the answers to these questions in order to match your fact pattern to the cases that we're aware of. And the reason that this is a topic today is because in 2014, the Supreme Court decided the Hearst versus County of Morris case. And this case, it stemmed the tide from some liberal decisions that were finding off-premises injuries compensable. And I don't want to go back too far in time, but I just want to point out, back in 1979, the statute was amended to try and limit off-premises injuries in terms of compensability. So it's redrafted to try and have cases found compensable that are closer location-wise to the employer's premises, because there were more exceptions than there were the rule. What happened from 1979 for the next 20 years or so is exceptions started to pop up again and again. And the Hearst case helped stem that tide. So let's talk about that just for a second. So in the Hearst case, from 2002 until 2010, the petitioner paid for her own parking at a lot behind the job site. The county assigned free parking in 2010 at a private garage about 2 blocks away. First come, first served, 65 spaces. So on the day of her injury, the petitioner parks in this garage, and she leaves the garage, and she's struck as a pedestrian walking one of the 2 blocks towards the office. So could the county possibly be punished for providing free parking? I call this case the no good deed goes unpunished case. And oh yes, according to the judge and the appellate division, providing free parking extended the employer's parking premises, the County of Morris, from the building itself 2 blocks all the way down to the garage. Now it's all County of Morris premises because they provided free parking. So in the words of my favorite coach, Coach Lee Corso, not so fast, my friends. So the Supreme Court stepped in, and they took care of this for us, thank God. And the Supreme Court said that both the judge and the appellate division were incorrect. They said the employer, the County of Morris, exercised no control over the petitioner's commute to work. Petitioner had every right to accept or reject the free parking. She could have continued to park out back and pay for it and walk 100 steps, but she wanted the free parking 2 blocks away. So, and the court pointed out the 1979 amendments were there for a reason, that to limit off-premises injuries as being found compensable. And so the Supreme Court really kind of stemmed the tide a little bit to some of these more liberal decisions. So the next question is, when the Supreme Court, like E.F. Hutton, when the Supreme Court speaks, does the appellate division and do the judges and the practitioners listen? And Joe's going to tell us that it seems that that's the case.
It absolutely has. In the case of Burke versus Investors Bank, that was a case where a petitioner was working at a job site, parked in a parking garage in the office building where the bank was located, and there was no assigned parking spots. So on the way into the building, the petitioner walks into the building, pushes the button for the elevator door opens, and the petitioner falls down. There was prior case law that used to raise the question as to whether that was under the control of the employer. Based upon the Hearst decision, the appellate division has now changed its course and said that that's not something that's controlled by the employer itself, because she fell in a common area. It wasn't an area that provided benefit and control of the employer itself. So she ended up losing, which is a very good case for us as of respondents, because it basically overturned the law and narrowed the scope as well.
Right, and the case that Joe's referring to, a case called Ramos, that involved an elevator. Mr. Ramos fell down into the bottom of the elevator. She had down one floor because the floor apparently wasn't there when the doors opened, unfortunately. And that was a multi-tenant building similar to the Burke case, but the court really bent over backwards to find that the employer had some connection to that elevator other than simply being a people transporter. And in doing so, they found that claim compensable. So you can see that the Hearst case has had an effect on some of these off-premises injuries. So, Joe, you're going to tell us about some other course and scope cases.
Absolutely, Jeff. One of the main issues that has started to arise in our practice is we're finding people that are getting assaulted on the premises. A lot of those decisions themselves are very, very fact-specific. So the question becomes is, although you get hurt during the course of your employment, does the incident that leads up to that assault arise out of the employment? Under the Rosario case, which is a recent decision, the petitioner was recently divorced from her ex-husband. Mr. Rosario calls to try and find out where she's working, and the state advises that she's no longer at a particular site, and they direct him to where she's currently working. At the end of the workday, she's leaving the site and goes into the parking lot and is assaulted and stabbed by her ex-husband. So not only does he attempt to stab her, but he ultimately ends up stabbing himself. Under the old case law and a lot of interpretations, someone might say that that's compensable because it came during the course of employment. But because it's factually not arising from anything to do with the job, the type of work that she performs, then the court found that it meets the one test, but it doesn't meet the other, so it becomes a non-compensable event. One of the concerns that you have to be careful with, however, is even if it's not compensable, you have to be careful in terms of whether or not a incident that happens at the workplace, if it's not arising from the course of employment, you very well might end up having third-party exposure and liability because of whether you're keeping and maintaining a safe workplace.
Right, because the employer loses the bar from a third-party lawsuit, because if the employee at the time they're injured is not deemed to be an employee, then workers' compensation not available to them. And if workers' compensation isn't available to them, then the defense of the immunity and workers' compensation bar isn't available to the employer. So the employee says, well, if I'm not injured during the course and scope of my employment, then they wouldn't be a trespasser, they'd be a business invitee.
Correct.
Whatever it is in a GL terms, there'd be a duty to provide a safe workplace or safe premises. And in this case, she was attacked by her ex-husband on premises. So, be careful what you wish for in these cases. You just have to be aware sometimes when you just deny an employment relationship, that lifts the cloak of the immunity defense.
The next case that we wanted to talk to you about was Joseph versus Monmouth County. And our title says, "What the heck is Susu?" Basically, the premise of this is you be careful you might get bad juju if you don't pay your Susu. What Susu is, apparently it originates in Ghana and the Caribbean, and basically everyone who works at this facility chips in a couple money towards a pot, to almost like an employee type of GIF, where they take care of everybody else. So if someone runs into a problem at home, they can dip into that pot of money to pay for whatever they need, and then everybody else contributes more money. So, for example, if you have 100 employees and everybody puts in $10, you have a $10,000 pot. It's an emergency service area that people can go to if they run into problems. kind of like a business cooperative type of thing. So the $1,000 would go to the first member of the group who needs the money, and then as that depletes, then everyone contributes again. So as we noted, as the moral of the story is sometimes if things are too good to be true, they probably are. So in this particular situation, Mr. Joseph doesn't appear to have paid his $10. So he's taking a nap on the job, and somebody comes in and busts him upside the head. And basically the question became is, he's in his employment at that time, or he's at the job. The question is does the actions leading up to this arise out of the scope of his employment? And the court found that it didn't, which was a really good thing because that could open up an entirely bad Pandora's box for everybody.
So keep in mind, when you have these type of claims presented to you, the assault claims, the key is to determine what is the basis for the assault. Is it personal animus, a Cowboys fan fighting with a Giants fan, or more likely an Eagles fan, a sad Eagles fan? That is not going to be a compensable scenario. So you're looking for what are they arguing about? Are they arguing about, I cleaned that already and you just made a mess of what I just cleaned? That's another matter. Okay. So the next defense we wanted to talk about is the idiopathic defense. So what we've been talking about are injuries that arise during the course of employment, which is time and place, or arising out of employment. Are they related to the job? This issue is the idiopathic defense. The injury arises during the course of employment. So the employee is where they're supposed to be during work hours. It is the employer's burden of proof that the injury itself and the disability is purely personal, that it has nothing to do with the job. Very difficult burden of proof. There's only a few cases on it, and recently we have another one. Again, it's unpublished, unfortunately, but these are the kind of cases we keep close to our elbow, bring them to the court and counsel's attention. So the scenario in this case, Fitzgerald versus Walmart, the petitioner is walking down an alley at work when she suddenly feels a pop in her low back. She's not engaged in any vigorous physical activity at the time. She's not carrying anything. She had just finished doing her normal job duties. And what's interesting and unfortunate for Fitzgerald is this appeared to be a very honest and straightforward petitioner. At no time from the time of the injury until the time this case is litigated does she gild the lily and add, and it was a particularly vigorous day of lifting. I lifted more boxes than I normally do. My boss had just called me and I returned to hear my name called or something like that. She didn't add any facts other than simply saying I was walking down the alley at work and my back popped. So is that enough to give rise to a compensable injury? Certainly she meets the criteria. Does it occur during the course of employment? Absolutely. During work hours on premises. Does it arise out of employment? That's the question, and that's what Walmart relied upon to deny the claim. And again, it is Walmart's burden to prove it was purely personal, idiopathic to her, and nothing about the job really contributed to it. And fortunately, the court in this case held that this is not a compensable scenario. There was no connection whatsoever between her job duties and the injury at work. It simply happened at work, but it's coincidental if there's no cause and effect. So, as I said, change the facts slightly. So that she's carrying something, that her name is called and she yells and turns quickly, that she's going up and down steps carrying something, that could change everything. Most often we see these come along with knee claims, where somebody's walking along and their knee pops. There are two cases out there. The most recent one is called Shoutus. Mr. Shoutus had just gotten out of his car on the employer's parking lot, so it's during the course of employment. And the facts were he was twisting and pivoting on his heel, he had his briefcase in his hand, and the court said those two factors were enough to make the popped knee work-related. So you can see how fact-specific some of these claims are. So the last topic of defenses we're going to talk about are the independent contractor defenses. And what's interesting about this is in June of 2015, the law was kind of turned on its head in a very unusual case that was not litigated in workers' compensation court. So we're going to take you through this case, and you can see the ramifications that may bleed over into workers' compensation court could be significant. Could be significantly helpful for respondents, but we'll see how that goes. In this case, and I'm going to call it the Liebman case because I have a very difficult time pronouncing Katsovska. In the Liebman case, she is hired as an aide for Mr. Liebman, and she's working full-time as a live-in assistant. She's paid $100 per day. And on the day of the injury, she goes with Mr. Liebman to a diner, and unfortunately, the elderly Mr. Liebman, who's in his 80s, is driving the car. So he's behind the wheel, and instead of pressing the brake, he presses the accelerator. He goes forward and he injures Ms. Kotskava, and the injuries are severe enough that she eventually dies from the injuries to her lower extremities. Now, she has no dependents. So what is the value of the workers' compensation claim? It's pretty much zero. The best case scenario might be a $3,500 funeral benefit. That's about it. So when she meets with her attorney and the attorney realizes there are no dependents to receive death benefits, the attorney decides, I'm going to file a lawsuit against Mr. Liebman and allege that his negligence caused her death, which was pretty clear. Negligence caused her death. But if he's her employer, there's no claim. She can't file a civil suit against her employer absent some exceptions like an intentional tort, and there was no evidence that this was intentional. It was simply an accident. So he goes to civil court, gets in front of a jury, and the jury renders a verdict of $550,000. In doing so, the jury says she's an independent contractor. And the trial court says, well, we can decide employment relationships. It doesn't have to be workers' compensation court. The appellate division says, no, you can't. You're a jury. This is civil court. Workers' compensation issues of employment relationships are decided by workers' compensation judges, and that's where this case should have been decided. So they think the case should have been transferred to the workers' compensation venue. The Supreme Court disagrees, and the Supreme Court says, no, the trial court, appellate division, we have concurrent jurisdiction to decide employment relationships, so the jury was within its power to do so, and they affirmed the $550,000 verdict because they say that Mr. Liebman was not her employer. It was an independent contractor relationship. In order to find an independent contractor relationship, however, and this is the key to the case, the trial level and at the Supreme Court, they came up with a 12-step analysis. A 12-step analysis to decide if there's an employment relationship. We don't have a 12-step analysis in New Jersey workers' compensation, but now we do. Because this court isn't used to addressing these type of issues. If this was in front of a comp judge, we would have had a two-prong relative nature of the work test. It's a very straightforward test. Is what the individual doing an integral part of the employer's business? Is the first prong. The second prong, are they substantially economically dependent upon the relationship? In this case, I think Ms. Kotskava, I said I wouldn't say her name, and I butchered it 3 times, would have been deemed to be an employee. And this suit would not have been able to proceed in the civil context. So in order to avoid a nuisance value workers' compensation payout, the law was kind of turned on its head to find Mr. Liebman to be not to be an employer, but to have an independent contractor relationship with the individual who we unfortunately killed in the accident. So what's the fallout of Kotskava? The case, within weeks after this, the Babaker case, I can pronounce Babaker better than her name, came out. And now this is in workers' compensation court. So are they going to follow the relative nature of the work test or not? Joe, tell us what happened.
Thank you, Jeff. In regard to this one, this is actually a very surprising decision because under the old terms of workers' comp, this probably is a compensable workers' comp claim. In Babaker, the petitioner's a limo driver. He works for AYZ. He's working 60 hours a week. He's driving limos for them. And not only that, but he's a part owner of the company. Prior to this, the court would have looked and said, does he have an integral business relationship to the employer? And was there a substantial economic reliance upon it? Absolutely. However, using the 12-point test, the court found that Mr. Babaker wasn't an employee despite his full-time relationship with the limousine service. He worked as a driver and derived all of his income from them. So, frankly, but for that 12-point test, this is one that the employer's probably eaten. The new approach in Kotskava, how's that? In a non-work related comp setting, now affects independent contractor analysis in all workers' comp claims. This is also somewhat of a double-edged sword too, because remember, if the petitioner is not working for you, then you have no Section 40 liens and things along those lines. But one of the further extrapolations that come off of this is that we believe that this Babaker case is Uber-esque. Although Mr. Babaker works directly for AYZ, he's doing a lot of things that an Uber driver would do. He maintains his own car. He gets assignments. He puts himself on and off duty, and he can choose assignments. So it's our belief that based upon Babaker, that any extrapolation now into Uber, which is less connected to an employer would basically allow you to consider them to be independent contractors as well. So even though we think that there's substantial economic dependence on the employment relationship, they're technically independent contractors.
Yeah, the Uber driver is going to be an easier case, and similar employment relationships where the individual has the right to decide to work, not work, how much they want to make or not make. Bobaker made a lot of money, 60
Right.
hours a week. Uber drivers, as we know, they either log on or don't log on. They can work 4 hours a week or 10 hours a week. If they don't log on, they're not available. Some other Uber driver will be. And there's litigation throughout the country now attempting to change the statutes. Uber really wants it to become statutory, that it is an independent contractor relationship. Because you can imagine if it's not, and they have to come up with workers' compensation coverage for the Uber drivers,
Yeah.
it's not going to be a lucrative business for them anymore.
Absolutely.
So these are some of the defenses that we wanted to talk about today. And again, keep in mind that these defenses are almost exclusively legal defenses. Now, they're based upon, and the underpinning are facts, which have to be flushed out very carefully. But they're legal defenses. And whenever there's a legal issue that we raise in front of a judge, the appellate division will take a look at legal mistakes. They are not keen on looking at credibility issues between fact witnesses or medical witnesses. That's why I have here, pick your fights wisely. If you're going to fight a straight credibility call, he said, she said, or which doctor is more credible, make sure you have really strong fact and medical defenses on your side. Get your fact witnesses to give their information in a statement. Confirm it immediately after the incident. Don't try and reach out, as I'm working on some cases now, 6, 9 months later, a year later, and ask a fact witness to help you with the incident itself. They're not going to remember the details, and they're certainly not going to remember them as well as the injured worker. Same thing with your medical experts. Make sure you choose the best expert, not just necessarily the hired gun, especially in a high exposure case. You want to hire somebody that the judge respects. And so rely upon your defense counsel to choose those. So those are just some of our recommendations. If you're going to fight credibility cases, make sure the evidence is really strongly in your favor. The courts will not reverse credibility decisions made by the judge unless they, violate all kinds of reason.
And
Joe?
one thing that I have a recent case that really is coming out fact specific. We have a claimant who is a foreign language speaker, and the insurance company tried to take a telephonic statement. And now there are questions as to what he said on the telephone, whether they were actually what he said, because the person who was interpreting on the phone was someone who was in the house. So if you're having a case where it's really going to be a fact-specific legal question, we would strongly suggest that you send an investigator out or someone to take some type of a sworn statement of the individual, so that way you don't run into that problem down the road.
Okay, so thank you for listening to us today. If you want to know more information about our workers' compensation series, or you would like to be added to our webinar email list, please contact Bisa Lindsay at blindsay@wglaw.com, and you'll see her number there, 267-765-4120. We have some upcoming events. In fact, on April 6th, we're having a live presentation at our Philadelphia location at 2000 Market Street, the rights of LGBT community in the workplace. We have a great group of panelists, including members of our firm and members of the mayor's office as well, and representatives from EEOC. That should be a terrific presentation. And we also have future webinars coming up. The WG University programs, you'll see them listed here, both Pennsylvania and Delaware. We're coming back in New Jersey on April 19th. And we're going to be talking about why does the New Jersey Workers' Compensation Court and system move so slowly, and what can we do about it? That's a constant complaint that we hear, so we'll be talking about that a little bit more on April 19th. So here's some of the ideas, some of the future presentations that we'll have by webinar, and again, we also have them in person as well. So we'll be looking for your questions after we close up today, and we'll be getting back to everybody's questions. So thanks again, and everybody enjoy your afternoon.